Okay, let's talk about something that's right at the core of Brazil's criminal justice system. It's the very first step, the foundation of it all, but it's also a huge battleground. We're talking about the police inquiry, the Inquérito Policial. This is where the state's power to investigate goes head-to-head with a person's individual rights. To really get a grip on the system today, you have to see how it's evolved, from this old-school, secretive process to the much more complex, guarantee-focused system we have now. So, let's dive in. So, the big question is, how does this critical first phase of justice actually work today? How has it been twisted and turned and reshaped over the past few decades? Well, we're about to break that whole journey down.
Here's our game plan. First, we'll nail down the basic function of the police inquiry. Then, we'll take a step back and look at its traditional, kind of secretive model. After that, we'll see how the 1988 Constitution just blew that all up, paving the way for the huge transformations we're seeing today. And finally, we'll connect the dots and talk about why all of this is so incredibly important for you to understand.
All right, let's start at square one. What in the world is the Inquérito Policial? So if you look at the Code of Criminal Procedure, it's basically an administrative procedure. Its job is to do two main things. First, to confirm that a crime actually took place. That's what we call materiality. And second, to gather clues about who might have done it. That's the evidence of authorship. The whole point of this is to hand the public prosecutor a file with enough information for them to form their opinio delicti, to decide if there's a strong enough case to actually press charges and go to court.
Now, to really appreciate where we are, you gotta know where we started. And the inquiry was originally built on this very classic, very inquisitorial model.
For a long, long time, you could sum it up with three words: inquisitive, secretive, and written. I mean, just imagine this, a totally one-sided investigation happening behind closed doors, where the suspect has almost no input and every single thing is written down and filed away. And this classic model had some really distinct features. It was run by the state, of course, that's oficial, and for most big crimes, it started automatically, which is oficioso. The whole process was kept under wraps, sigiloso, and it was totally one-sided, or inquisitivo. Everything, and I mean everything, was written down, making it escritinado. And maybe most importantly, once an inquiry started, the police couldn't just decide to drop it. It was indisponible. Only a judge could officially close the case. This whole structure gave the state a massive amount of control. But then, 1988 happened, and the new federal constitution wasn't just another law. It was a total game changer that basically crashed head-on into that old traditional model.
And this slide just lays it out perfectly. Before '88, everything was inquisitorial. After '88, we started moving towards an accusatory model. And what that means is you separate the jobs. One person investigates, another accuses, and a third person judges. That's key for fairness. The old rule of secrecy had to make way for fundamental rights, and the idea of a limited defense got replaced by this powerful principle of a broad defense.
And this wasn't just some theory. The Supreme Court made it real with Súmula Vinculante 14. This is a binding rule that says a defense lawyer has the right to see all the evidence that's already been documented in the case file. Now listen to that carefully, already documented. This means the police can still keep their active, ongoing investigation secret, but they can't hide what they've already put in the file from the lawyer. For the defense, this was a monumental win.
But the story doesn't stop in 1988. Not even close. In just the last few years, we've seen some of the biggest changes yet. And these are things that you, as future lawyers, will be dealing with every single day.
Okay, let's talk about a big one, the Juiz das Garantias, or Judge of Guarantees. This was introduced in the 2019 anti-crime package, and it was supposed to be a revolution. The whole idea is to have one judge who only oversees the investigation phase, protecting rights and ensuring everything's legal. And crucially, this judge would be totally separate from the judge who later handles the trial to avoid any bias. But, and this is something you absolutely have to know, its implementation has been suspended by the Supreme Court, so its actual future is one of the hottest debates in Brazilian law right now.
So what was this judge supposed to do? Well, their main job would be to act as a referee during the investigation. They would be the ones to approve big invasive measures like searches or wiretaps. They'd manage the deadlines. And really importantly, they would have the power to shut down an investigation if it just didn't have a solid basis. This would have been a huge check on investigative power.
The anti-crime package also tried to completely change how inquiries are closed or archived. Under the old system, the prosecutor asks a judge, and the judge decides. The proposed new system gives the prosecutor the power to just order the archiving themselves. The oversight would move from a judge to a review board inside the public prosecutor's office. Just like the judge of guarantees, this change is also on hold, but it shows a clear trend, trying to give prosecutors more autonomy and fully embrace that accusatory model.
And speaking of the public prosecutor, here's a change that did stick. The Supreme Court confirmed that prosecutors can run their own criminal investigations. This ended a huge debate about whether only the police could investigate crimes. So while the police inquiry is still the main way things are done, the public prosecutor can and does run their own investigations, called a PIC, which is short for Procedimento Investigatorio Criminal.
Okay, so we've looked at the definition, the history, the classic model, and these huge, sometimes still pending modern changes. But let's get to the bottom line. Why does this really matter to you, a law student who's going to be in the trenches soon?
This quote really just nails it. To get this stuff, you can't just memorize the legal code, you have to understand the constant tug-of-war between old traditions, new court decisions, and changing laws. This isn't some dusty, settled topic, it's a living, breathing part of the law that's being shaped as we speak.
When you're a practicing lawyer, these are the exact tensions you're going to live with every day. How do we make sure investigations are effective without stomping on fundamental rights? How much secrecy do we need versus how much transparency does the defense deserve? Where is that line between the power of the state and the protection of the individual? These are the questions at the very heart of the modern police inquiry.
And that brings us to the ultimate question, doesn't it? As Brazil keeps tinkering with its criminal justice system, always caught in this push and pull between efficiency on one side and guarantees on the other, what do you think the future of criminal prosecution is going to look like? The next chapter is being written right now, and pretty soon you're going to be the ones holding the pen.